Next case on the docket is McMillan versus Smith.
Good morning, Your Honors. My name is Annabelle Majeski. I'm here representing Ms. McMillan, and I'd like to reserve 5 minutes for rebuttal, if I may. We're here seeking a new trial on damages, finding that the jury's failure to award either past or future non-economic damages and the inadequacy of the past medical expenses especially, was inadequate.
Let me ask you on the pain and suffering or the non-economic damages, was the jury instructed that if they found no permanency, then they were not to award non-economic damages?
I think that's what the verdict says. I have it here.
Okay.
I think that's what the verdict said.
And was that an instruction that was agreed to by the parties? And
I did not see anywhere in the trial transcript or that there was an objection to that.
okay, is it an accurate statement of the law? Was the jury instruction an accurate statement of the law?
Not as far as I could see. I think we also argued in our brief there is that whenever there's evidence of pain and suffering, I think regardless of permanency, Ellender v. Bricker says that an award for pain and suffering is required.
Was that a car accident case?
Um,
Or is that a different type of negligence case?
No, this is, it was negligent operation of a motor vehicle, so it was an accident case. And it's second DCA, and it's 967 Southern 2nd, 1088. And it says, the thrust of the argument in that case was that the zero award for past and future non-economic damages was inadequate in light of the evidence presented at trial. Therefore, in this case, I cited it for the fact that I think that the appellees had made an argument that by not asking for a mistrial on certain things.
Well, was there finding of permanency in that case by the jury?
It doesn't seem to say. That's what I said. It doesn't really address whether the injuries, it just said that since there was undisputed evidence of pain and suffering, that there should have been an award for pain and suffering.
Counsel, what evidence would you point to in this case that would require an award for pain and suffering?
Besides Ms. McMillan's testimony as to how much pain she was in, Dr. Katzman, her surgeon, testified as to the pain and suffering.
Related to the surgeries?
Yes. But before that, Dr. Meredith, who was treating her before she had the surgeries, also said that she was in so much pain, and that's why she then, referred her to Dr. Katzman for surgery. So from the beginning, she was in pain, even when right after the accident, when she went to the emergency room. And that pain continued. And of course, it was the whole time that she was pregnant, it wasn't treated, and so then it continued even more after that. Then let's see, on,
Was there any pain and suffering that you're claiming that wasn't connected to the surgeries?
I think that wasn't connected to the surgeries.
Correct.
Well, the pain and suffering at first that required the surgeries was the injury to the neck and the lower back.
that
So
pain
that
and-
was in other words, she was in pain and they couldn't do anything about the pain and the injections didn't work to alleviate the pain and therefore she had the surgery and then the surgery of course hurts.
So it was
So-
connected to the surgeries, though, is what I'm trying to find out. Was it connected to the surgeries?
Well, it's connected to the surgeries in the fact that if she didn't have the pain and suffering, she wouldn't have needed the surgery.
Okay.
To
So
correct the
wasn't there
pain.
evidence at trial, though, that the surgeries were not related to the accident?
The treatment, you're talking about whether the treatment was necessary. Of course, Dr. Katzman and Dr. Meredith testified that they were. Dr. Duran, who basically emphasized what her future medicals would be, he also said that her treatment was necessary.
What about Dr. Maluso?
I was saving him for last because he's the only one that you could say presented conflicting testimony. He said, but his focus was on causation. He basically said that the treatment wasn't necessary because in his opinion, the injuries were not caused by the accident. But we know that the jury found that her injuries were caused by the accident. So that sort of takes away his opinion as to whether the treatment was necessary or not. But he
Did you raise the issue of an inconsistent verdict?
We did an inadequate verdict. You mean before the jury was discharged?
An inconsistent verdict. Did you raise the issue of an inconsistent verdict?
Not before the jury left. They raised it in the motion for new trial. But is it really inconsistent or is it just inadequate? I was a little confused about that, so I leave that for your honors to decide whether it was inconsistent or inadequate. Because some of the cases say if they award something and what we're really saying is you didn't award enough.
Dr. Maluso didn't testify that there was no treatment necessary. He testified that only the chiropractor was necessary. Is that correct?
What I read last night was that he testified that the treatment that she received was related to her symptoms. And he could not come up with any other cause for her injuries other than the accident. Like I said, the focus of his testimony was on disputing causation.
Well, didn't she, you said there's no other cause, but she had a 2004 accident. She had a 2007 accident, which is the subject of this case, and then she had a 2009 fall. So actually there was 3 possible causes or some combination thereof, right?
Well, there was a lot of questioning about whether the 2004 accident could have prevented her.
In the 2004, she went to the emergency room and complained of neck pain, back pain, left arm, and leg pain, and she didn't disclose this in discovery. She didn't disclose it to her treating physicians. She didn't disclose it to the CMI doctor. I mean, could the jury have properly considered all those factors?
I think there was some discussion about that, and what it came out was, I don't know if it was Dr. Katzman or, let's say it was Dr. Katzman that was questioned about it, and also it came out that after that 2004 accident, she then continued to work, and there wasn't any, other than going to the emergency room and complaining about neck and back pain, there wasn't any doctor treatments or anything else about it. So obviously it was sort of nominal and didn't really have any effect on anything. And then there was also testimony that if there had been, say, the degenerative disc disease that the defense was pushing was the cause of her injuries, not the accident, say that had started in 2004. Even so, the 2007 would have aggravated that condition. But there is no evidence that the degenerative disc, other than the defense experts that were disputing causation. But as I said, the jury determined that this accident did cause the injuries that she had, and they were aware of the 2004 and the 2009, the accident and the fall. So, and they still found that this accident caused the injuries that she had the surgeries for. So after we've determined that, yes, this accident, the 2007 accident, caused the injuries, then we have, was the treatment necessary? And Dr. Maluso was the only one who said that the treatment was not necessary, but that was based on his opinion that these injuries were not caused by the accident. So then we go to whether the injuries were permanent. Dr. Katzman said yes. Ms. McMillan testified as to her scarring, and so did Dr. Katzman. I will concede at this point, Your Honor, that the scarring was minimal, and the jury could have found that there's no permanency based on minimal scarring. But of course, the other one is, the other part was whether it's affected her ability to do anything. And Dr. Duran did testify that her neck pain is permanent and makes her totally disabled. And even the trial court, I have that here, questioned on page 27 of on the motion for new trial. I don't have we supplemented the record with it, so I don't have that. Oh, excuse me, yes I do, page 4601 of the record. The trial court is questioning, it says, I may be wrong in my analysis, but this is ultimately unbelievable. We have Ms. Coleman who testifies and says, oh, this is about some portion of the cervical bills were properly coded and the jury awards that, meaning that the jury has paid those treatments and the injuries associated with that treatment are reasonable, necessary, and related, and causally related to this collision. And then you have your own physicians, he's talking to the defense counsel, who stands up and says, I don't agree these injuries are related to this accident. She did not suffer permanent injuries as a consequence. She did not as a consequence of this accident, she did not. But that surgery, this is the court's opinion, that the surgery has now caused her a permanent injury, because the fusion means that she can't move her neck, and also with the spine. I mean, the vertebrae are not fused, so she's lost mobility there too, and including the fact that some of the some of her examinations showed that she's lost mobility.
Going back to the verdict form, I wasn't clear. Did the appellant object to the verdict form?
I do not see that the appellant that we objected. And yes, it does say here, I have it now. Did Kendra McMillan sustain an injury as a result of the October 21, 2007 accident that consists in whole or in part of either one, a significant and permanent scarring or disfigurement, which I concede was minimal, an injury that the evidence shows is permanent within a reasonable degree of medical probability. That's the part we say, for sure. The evidence definitely shows that she suffered permanent injury.
Well, the jury checked no on that.
Yes, they did. If your answer to question 4 is yes, please answer question 5. If your answer to question 4 is no, please skip question 5 and proceed to question 6. And then it's, question 5 is, what is Kendra McMillan's total amount of damages for pain, suffering, disability? So the jury followed the instructions, but the instructions are incorrect as a matter of law, because whether she had, there's no question that she had pain and suffering before the surgery caused by her injuries sustained.
Well, your client didn't object. Is this fundamental error?
If it's a misapplication of the law, if this is incorrect and that's not the law, yes, it is fundamental error, Your
So
Honor.
just because your position is it's fundamental error just because it's legal error is fundamental error?
Well, when it affects the damages and the fairness of the trial and everything else, and it goes against the evidence that was presented as far as damages goes, yes, it is, Your Honor. And we did not waive it because we did bring it up at the hearing on the motion for new trial. And even the judge felt that there was permanent injury, and so he's sort of agreeing if there is personal injury, the case law says that she should have been awarded pain and suffering, at least past pain and suffering. And then we get to the question of the reasonableness of the bills. The only people that really gave an opinion was Dr. Maluso, but he basically said he had no opinion as to whether the bills were reasonable, because he was still stuck on the fact that they weren't necessary because they weren't caused by the accident. And then we have Ms. Coleman, who was precluded from the grant of a motion in limine from opining as to whether the bills were reasonable. She was only supposed to testify as to whether they were properly coded. She found that they were not, and it was a backdoor opinion as to reasonableness to the fact that bills that are not properly coded should not be paid. So that's basically saying if they're not properly coded, they're not reasonable expenses. And that is evidence, the harm to the plaintiff is evidenced by the fact that originally she had examined 900 and something thousand worth of medical bills, and then she boiled it down to that only $238,054.61 were properly coded, and the jury awarded in past medical expenses $203,054.61 in past medicals. So her testimony definitely was a huge influence, and she was supposed to have been precluded from giving her opinion as to the reasonableness of the bills, and instead she sort of said, well, I'm only telling you what's properly coded, and those are the only things that should be paid. So she, like I said, they backdoored the reasonableness opinion. And those are the only two people that really came right out and said anything about reasonableness. Dr. Maluso said he had no opinion, and Ms. Coleman, who said if they're not properly coded, they shouldn't be paid. And I'll save the rest of my time.
All right, you have just under 3 minutes for rebuttal.
Thank you.
May it please the court. I'm Alyssa Ryder from Wicker Smith on behalf of the appellee. Before getting to the merits, I did want to raise one housekeeping matter. I noticed in preparing for the argument today that through a clerical error, our table of citations lists the page numbers for all of the cases in the brief, but the page numbers are off by a page or two. And at some point in updating the brief. If the court wants, I would be happy to provide an amended table of citations if the court deems it necessary.
No.
If not, I'll just get to the merits. And I did mention it to Ms. Majewski this morning as well. On the merits of the case, I have to say, in some ways, I'm taken by surprise this morning because it seems like a different case than was argued in the brief. To begin, I don't recall seeing anywhere in the brief where the inadequacy of the medical damages awarded was ever raised as an issue. And now we're discussing the merits or not of the jury instructions and verdict form, which counsel concedes that she knows of nothing in the record indicating there was an objection at trial, and that was never raised as an issue in this brief either.
Let me ask you, from a big picture perspective here, it seems to me both sides had a lot to work with the trial. I mean, the plaintiff had their experts, they had witnesses about how this injury had affected her, et cetera, and then the defense had a lot to work for because there were a prior incident, a subsequent incident. The actual collision doesn't seem that major, but it just seems to me that the most logical thing for the jury to have done one way or another was, if they were going to find no permanency and that the only thing that happened was, some sprains, et cetera, that the damages should have been a lot less than $220,000 or $230,000, whatever it was. But if the incident did contribute to 6 herniated discs and her surgeries, et cetera, then there should have been, a finding of permanency with an award of pain and suffering. So, at least from the big picture, it seems to me that the verdict didn't make a lot of sense in that regard. Could have gone better for you, could have gone better for them. Did either side ask the jury be sent back for an inconsistent verdict?
No, and certainly that's not the defendant or appellee's burden. I think the court's
Was that a fair assessment, though? In some ways, the jury verdict doesn't make a lot of sense?
No, I don't agree with that assessment, and I'll explain why in a second. But first, I want to point out that if what you're saying is that to you there seems to be a disconnect or an inconsistency between the amount awarded for the medical bills and the finding of no permanency, if that is the issue, and that does seem at times to be the issue raised by the appellant, then they had to object at the time the jury rendered the verdict, and they had to raise the issue then. And then the jury could have been sent back to deliberate further if there really were an inconsistency. And preservation of error seems to be sort of a theme today, and that's a major problem for the appellant's case today. They have
I don't disagree with that. I'm just trying to figure out, I want to hear how the jury could logically have come to the conclusion they did.
So there was a lot of conflicting and often confusing testimony about the amount of the medical bills. The plaintiff put up for the jury bills of about $857,000. The defendant's expert, Connie Coleman, said that she was presented bills to look at the amount of about $936,000. So right there was a disconnect about what the amount of the bills really were. Dr. Katzman, who was the plaintiff's primary treating doctor and probably the major expert testifying for the plaintiff at trial, he admitted that there were mistakes in his billing department. So, for example, there was testimony where the defense had been presented a bill for $370,000, but then Dr. Katzman said that bill was only $240,000. This is on page 5842 of the transcript. That's just one example where there was just a wild disparity in the bills as asserted by the plaintiff and as received by the defendant, and then what the reasonable value of the medical treatment was worth. Now, the jury, we just don't know how they came up with the number they came up with. If they decided that one surgery was appropriate, but the other ones weren't, that all of the treatment was appropriate, but yet there was no permanent injury because she was restored to a physical state where she didn't have an ongoing problem, whether the jury found that just one surgery was proper and the others weren't. There's no way of going back and figuring that out because, again, there was no itemization, there was no request that the jury re-deliberate. And the cases we cited, Emanuel versus Purdue and Smith versus Lamas, they both discussed the fact that the trial court can't act as a seventh juror, and certainly if the trial court can't, then the appellate court cannot sit as a seventh juror and then reevaluate for itself what the evidence is. The case law says that so long as there is conflicting evidence, it's up to the jury to decide it. And here, there was certainly conflicting evidence. On the issue of the instruction about the permanency, not only was that not error for the judge to provide that instruction, and not only was it waived, even if it had been error, but I just want to point out that it's not error. We cited in our brief the case law and the statute 627, 737, which provides that unless you make a threshold finding of permanency or of significant and permanent scarring or disfigurement, then a jury cannot award non-economic damages. So I'm a little perplexed why we're even arguing that this morning. And the appellant has conceded that there was no significant scarring. So that's not even an issue anymore. The jury could have found that there was no permanent injury within a reasonable degree of medical probability. We, the defendants, presented expert testimony of Dr. Maluso, who was an orthopedic specialist who actually performed an examination on the plaintiff, and his opinion was not solely related to causation. He examined her, and he explained that he did not see any significant limits in her range of motion. He found that her examination was mostly normal. He did see some degenerative changes. We had expert testimony from Dr. Foley, a radiologist, who reviewed all the films, and he said what he saw was an ongoing degenerative process in this woman's spine. So there was substantial conflicting testimony and substantial evidence that would support the jury's finding that there was no permanent injury as a result of this accident. The appellant raised this morning a point about that obviously the 2004 car accident created just minimal damages. But there's nothing in the record that would support that statement that it's obvious. There was a great deal of conflicting testimony as to the 2004 incident. In terms of obvious, we should note that the 2004 incident occurred when the car that the plaintiff was in was going about 40 miles an hour and rear-ended another car, whereas the accident involved here in 2007 happened when the plaintiff's car was going relatively slowly because of traffic and another car sideswiped it. There was no damage to the rear of the vehicle. The airbags didn't deploy. There was no evidence that Ms. McMillan struck anything within the car. So it's a misstatement to say that it's obvious that the earlier accident was minimal. I do want to raise...
Counsel, as to the Coleman's testimony, the issues raised by the appellant, on this record, were any of those preserved on this record before us?
No. No, there is a major problem with preservation of error of that point on multiple levels that, as I raise in my brief. To begin with, the portion of the trial transcript that has the apparently offending portion of Ms. Coleman's testimony is just missing from the transcript, where this incident occurred and where there was the objection. That is nowhere in the transcript. In the reply brief, the appellant said something to the effect, well, there was no transcript made or something. I wasn't really sure what that statement meant. But the thing is, either the court reporter took down that testimony, but it was just never ordered or transcribed and filed. I don't know why. Or I suppose it's possible the court reporter didn't transcribe that portion, didn't report that portion of the trial, but Rule 9.200 provides a means for parties to prepare a bystander's report, a statement, and have the trial court approve it and file that. But the appellant didn't do anything, even after I pointed out at length in my answer brief the problem in the transcript. There was no effort made to try to supplement the transcript in any way. So that's one way in which this is waived. I did give the appellant the benefit of the doubt and looked at the transcript on the post-trial hearing where the counsel were discussing what happened. And according to that transcript, which again is not the transcript of the actual incident, but the attorney's after the fact discussion about it, it appears that what happened was that Ms. Coleman, sort of in her background testimony where the counsel was asking her, well, what is a CPT code? She began to hold up the CPT code book just to say, well, this is a book that has the different codes for different medical procedures. There was an objection made. That's what the post-trial transcript shows. But according to that post-trial transcript, although an objection was made and sustained, plaintiff's counsel didn't ask for curative instruction, didn't ask for a mistrial. And so under Murphy versus Robotics, we'd have to use a fundamental error standard. The Campagnoni case that we cite clearly says if the court sustains an objection, you have to ask for a mistrial in order to preserve the issue and request a new trial on that basis. So it was waived for that reason as well. And also I point out that appellant doesn't use the right standard of review in discussing this issue. If they were going to raise this at all, it clearly had to be under a fundamental error standard. I pointed out what the fundamental error standard was in my answer brief. It still was never addressed, even in the reply brief. And this couldn't possibly meet the fundamental error standard because it was a fleeting reference, part of her background information, and the motion in limine at issue said that the expert couldn't use the book in order to present her opinions to the jury, and the book was not used in expressing her opinions. So even if the appellant hadn't already waived this 3 different ways, there's no merit to the argument. I think the bottom line, looking at the big picture, as Judge Evander said, at the big picture here, we have a case where the plaintiff had not only a previous accident, but then a subsequent fall. She had lied to all of her doctors about her medical history, about the fact that she had had this 2004 incident. Many of her complaints were subjective, and so the jury could decide whether to believe or not believe her, given her history of having lied. And there were competing experts on each side who said it was permanent, it wasn't permanent, treatment was necessary or not necessary, and whether she even had the sort of acute disc herniations she claimed she had. Our experts said that she didn't, that it was just degenerative disc disease. So there was substantial testimony to support the verdict that the jury reached, and there's no basis for the court to overturn it. The trial court, who sat there and listened to it all, found no basis to overturn it, and the appellant certainly hasn't shown an abuse of discretion in the trial court's decision to deny the new trial. We ask that you affirm the judgment. Thank you.
Thank you.
Dr. Maluso, at page 326 through 333, down to 362, et cetera, of the trial transcript is where we find Dr. Maluso's testimony. And he did perform the CME on behalf of the defendants. He agreed that the 2004 accident, even though he's the one, he was testifying that her injuries were caused by disc herniation, not by the 2007 accident. He was basically, his focus was on causation and the fact that the accident did not cause her disc injuries. It was herniation but he did admit that in the 2004 accident did not cause she had 7 herniated discs. And he said there's no way that 2004 accident caused all 7 discs to be herniated. His exam showed her range of motion was, in one case, 50 out of 90, 5 degrees out of 25 degrees for the backward motion, and her leg lifts was, her left leg was 10 out of 25 in bilateral motion, and the right leg was 5 out of 25 in the bilateral motion. She could only rotate her arms 90 degrees instead of 180 degrees. And the decreased motion was in the cervical spine. And he also said, he was also saying that the accident did not cause spurring and multi-level disc dehydration. So that's why he's the only one that had anything to say in opposition to Dr. Katzman and Dr. Moran as to the permanent injury. And he said there was no permanent injury to the neck, to the cervical spine, but he didn't say anything about the lower back. He did say that the side swipe cannot cause multiple herniation, but we seem to have been minimizing this was just some side swipe. This was a big truck that came out and hit their little PT Cruiser, which then the truck came up over their car, landed on their hood, and propelled them into a big Cadillac that was in front of them. It wasn't just this little tiny side swipe to minimize, she couldn't possibly have been injured. And I see that my time is up, so I will rely on my briefs for the rest of the arguments, and I thank you very much for your time.
Thank you, counsel.